All righty, good morning. My name is Felicia Orth, hearing officer for OCC 24683, hearing before the Oil Conservation Commission on well plugging and financial assurance. We're on day 10 of the hearing and have reached another of the public comment sessions. Just a few things about public comment. I'll invite it from those in the room and those on the platform. I'll ask you to state and spell your first and last name because we are making a transcript. Pursuant to the commission rules, I will ask you if you swear or affirm to tell the truth, and then I'll ask you to keep your comments, your oral comments, to 3 minutes. If you have more to say than can be said in that time, please submit your comments in writing to the Commission Administrator, Sheila Apodaca. So let me start with those in the room. Ma'am, would you like to offer public comment? All right, come on up to the witness stand if you would.
And I stand because I'm a teacher, and when I teach, I stand.
All right, thank you. Would you spell
I'm a
your first and
retired
last?
teacher. I retired twice. My name is Laureen Peppersack, Laureen Peppersack, P-E-P-E-R. I'm full of pep, not the spice. S-A-C-K,
Do you swear-
M-S-T, Masters from New Mexico Tech.
Do you swear or affirm to tell the truth?
Say what? Oh, I swear to tell the truth.
Thank you.
I'm
I'll
an
start
honest
your.
person. I always tell the truth. No kidding in my classroom. Now, as a teacher, one of the most disturbing things is when students come into the classroom who've never been taught to clean up after themselves. As a teacher, I want my classroom clean because I know that's an environment where my other students can learn. Also, if I have to spend time reminding them to clean up before they leave my classroom, what that means is that impedes learning time. This is a lesson that should be taught in homes. Unfortunately, it's not. Children don't have to clean up after themselves. Maybe there's maids, maybe there's other helpers. In my classroom, you clean up after yourselves. I will stop you at the door and keep you from going out until you clean up. Now, as adults, we should know that as well. We clean up after ourselves. We don't litter. We don't throw trash on the ground. And if we do something that's destructive, we fix it afterwards. The oil and gas industry, thank them for the money that they provided to teachers. They should provide more because it'd be nice if I didn't have to get a second job. But when you make a mess, you clean it up. If you want to drill somewhere, you clean it up. You have to clean it up so that it's in better, the water's better for the future, the environment's better for the plants, the animals. That is good, not just good citizen, but being a good human being. Profit. Oh, right, profit. Do you know what? I bet if this state required the oil and gas industries to clean up afterwards, invest a big bond, they'd figure out ways to not make such a mess. You're smart people. You can figure out ways to make it better. You can figure out ways how drilling will not impact future issues. Now, in school, if you don't like the way I teach, you can go to another school. We have the oil and gas here. We have the power here. Our government has, our state has the wealth that other states don't have. Yeah, you can go to Delaware. You can go to New Jersey. You can go to Idaho. Our Permian Basin is rich, but it's only rich if we take care of it. The greatest riches we have, and if I look around, I see how many people having water with them. The greatest riches we have are our water resources. You contaminate the water, there ain't no going back. We already have to worry about PFAS, those little plastics. But oil and gas industries, the way they use the water, the fracking, I've protested several times or spoken several times in front of government agencies. I was at the one where the Santa Fe County community stopped fracking down my old road, General Goodwin Ranch Road, and the public was outraged because our water is necessary for life. Like the native people say, water is life. And those of you who don't get that, try to go 3 days without drinking anything. Oh, right. Yeah, you can't. You'll get sick. So unless money, profit stops being the motivation, and instead responsibility, and you take responsibility by putting on bonds that require them to come back and clean up. We already have enough oil wells and mines that are wasting and polluting our native communities, polluting a lot of our communities. that haven't been cleaned up. We've seen what that behavior has given us. It ain't good. It's not good for our children. It's not good for our future children. And it's something we need to recognize as a society. We are a community. You do something, it just doesn't impact you. We're connected. It impacts every single person in the community, this generation, the next generation, and sadly to say, many generations after that. So what I'm asking you, please put a serious bonding so that their minds are restored to their pristine conditions as best possible. If you can't do it, don't try to drill there. Yeah, you can go somewhere else and do it. If it's too expensive, it impacts our profit. So what? Your biggest profit is having a beautiful environment, having a place that's safe for your children. That's really should be the most important thing for you. How is your community? How are you doing something that's leaving a better future for your children? And if you don't have children, I'm sure you have nieces and nephews that matter. How can we do this? And this is the responsibility of my government. And I want to thank you for allowing these public hearings, because people like me need to speak out. Usually it's middle schoolers I get to talk to and I make my waggy hand, because you need to pay attention. And I have changed middle school minds, and I know I can change minds here too. So again, thank you very much. Please take responsibility. Forget the little money dollar, because you ain't going to heaven with a billionaire. The old saying, rich people can't go to heaven like putting a camel through the eye of a needle. So do good things. Your heart will be better for it. Your community will be better for it.
Thank you, Ms. Peppersack. Who else in the room would like to offer public comment this morning? Ma'am, come on up. If you would state and spell your first and last name, please.
My name is Susan Homer, Homer.
All right. Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
I'm commenting in support of the rulemaking to modernize New Mexico's bonding and cleanup rules. I'm one of most New Mexicans who want the oil and gas industry to clean up after itself. As we heard, that's just common sense. If you make a mess, you clean it up. That's what we teach our kids, and it should apply to corporations also. We taxpayers are essentially subsidizing the industry by allowing the oil and gas industry to get away with not paying their own costs. Excuse me. Cleanup should be a regular part of doing business. And bonding rules should apply to all wells and all well owners, large and small, on all New Mexico lands, public and private, except tribal. State and federal funding for cleanup is taxpayer money. Why should we citizens pay for this? Nearly $100 million in public funds have already been used to plug orphaned wells, and thousands more wells are at risk of being abandoned. I want my taxes to go for schools and healthcare, not to bail out wealthy polluters. Bonding is about prevention, about making sure corporations pay up front so the public isn't left holding the bag. Some in the industry argue that we don't need bonding reform because there's already money in the reclamation fund. But that's not a solution, it's a warning. The reclamation fund exists because bonding is failing, and there's not nearly enough in the fund. We're looking at up to more than $1.5 billion in cleaning liabilities, and the fund only has around $66 million. These are our lands, our waters, our air, and our communities at risk. Oil and gas corporations don't need more ways to dodge responsibility. They need to step up and pay their fair share, just as the rest of us do.
Thank you, Ms. Homer. Who else in the room would like to offer comment this morning? No? We may have some folks on the platform. If you're on the platform, raise your virtual hand. If you have dialed in, use *5 to raise your virtual hand. Let's see, we have Melissa Ostroff. Can you unmute yourself?
Yes.
Oh, great. Would you spell your first and last name, please?
It's Melissa Ostroff.
Thank you. Do you swear or affirm to tell the truth?
Yes, I swear to tell the truth.
Great. Go ahead.
Good morning, commissioners. My name is Melissa Ostroff, and I'm the Pennsylvania Policy and Field Advocate with Earthworks, a national organization working to protect communities and the environment from the adverse impacts of oil and gas development. In my work, I use optical gas imaging cameras to document methane and other pollution that is otherwise invisible, making clear the scale of the oil and gas industry's impacts on our air, water, and climate. In Pennsylvania, I've filmed hundreds of leaking wells, many abandoned for years, even decades, venting methane and carcinogens like benzene into our backyards, parks, and schoolyards. Pennsylvania was the birthplace of the U.S. oil industry, and our wells are among the oldest in the nation. We've been dealing with the orphan well problem longer than almost anyone, and we've seen firsthand how failing to require adequate bonds early on leads to massive, lasting cleanup liabilities. I've met families who have lived with abandoned wells in their own yards. One woman I met, Pam, resorted to stuffing home insulation into a smelly wellhead near her garden because no one, neither the state nor the operator, would take responsibility. That was 4 years ago, and the well still hasn't been plugged. There are real long-term costs of insufficient bonding, and it's not just a Pennsylvania problem. Every state that has allowed operators to post inadequate bonds has ended up with taxpayers footing the bill for cleanup. The IIJA's federal well plugging dollars are already stretched thin, and they are temporary. Once they're gone, it will fall back on states and ultimately on communities and taxpayers to clean up this mess. That's why New Mexico's bonding reforms are so important. They represent one of the very few real chances we have to prevent another generation of orphan wells, and they could set a precedent for the nation. Strong bonding ensures that when an operator drills a well, they're also responsible for cleaning it up. It's about accountability, fiscal prudence, and environmental justice, not punishment. We've seen in Pennsylvania what happens when bonding levels are frozen or set too low. The problem multiplies, pollution spreads, and the cleanup bill grows. I hope New Mexico will choose a different path, one that puts people to work plugging wells, protects future generations from inheriting this liability, and ensures that polluters, not the public, pay to clean up the mess they've made. Thank you for your time.
Thank you, Ms. Ostroff. William Miller.
Okay, I think I'm unmuted and camera, let's see here. Let's get me on. There we go.
Hello. Would you spell your first and last name, please?
Sure. William, and my last name Miller, and I swear to tell the truth.
Great. I'll start your time.
Okay. Good morning, Chair and Commissioners. My name is William Miller, and I'm speaking on behalf of myself and the Sierra Club of New Mexico in strong support of the proposed bonding and cleanup rule changes at OCD. I live in Albuquerque, New Mexico. I grew up in Farmington, New Mexico, where my father worked for an oil and gas service company. And I have worked myself in the San Juan and Delaware basins, as well as in Southeast Asia and their petroleum fields. I have experience in the wireline industry with both open and cased hole operations, including the running of cement bond logs. And I have seen firsthand the mess left behind by both major and independent oil companies in New Mexico. And I've also witnessed the mess made in countries where there is little or no oversight or regulation. While there are millions of ticking time bombs around the world in the form of orphaned oil and gas wells, and thousands of those happen to be in New Mexico. These wells were not plugged or capped properly to begin with, and many have been deterioration of downhole conditions, such as corroded casing and poor cement jobs. Well, this allows for communication of fluids between pay zones and groundwater, as well as surface pollution, not to mention the leaking of poisonous gases such as hydrogen sulfide, which is common in the Hobbs and Barker Dome areas of New Mexico. And we pass the costs of fixing these problem wells on to the taxpayers. And that adage about pay me now or pay me later reminds us that we are passing this problem on to our children and grandchildren. And while we have not paid to play as we should be being, pay to play. And we have a chance to change this problem and correct this lapse of judgment. There's no excuse not to hold oil and gas companies responsible for their actions from the very beginning while they are calculating the true cost of drilling and production. The proposed bonding and cleanup rules do just that. So let's not play a game of catch up or finger pointing about who is responsible, because we know who is responsible. Now there's good work being done. I see this each time I travel up New Mexico 44, well, otherwise known as US 55, to visit my sister. And I passed an Envirotech land farm where they're claiming land soil that has been contaminated by oil and gas wells, as well as tank farms. So I know that there is some good work out there. So we need to reform the bond and cleanup rules and apply them. Now, to paraphrase an old Seinfeld TV episode, was that about renting a car, anybody can make a law. The most important action is to enforce the law. So thank you for your time and consideration about this important matter to me.
Thank you, Mr. Miller. Is there anyone else on the platform who'd like to offer public comment at this time? Our next opportunity may be at 4 o'clock this afternoon, if we are still in hearing at 4 o'clock this afternoon. The next public comment we're sure to have is 9 a.m. Monday. No? All right. Let's go back to the technical case, Mr. Sporich. Thank you. When we broke last night, it was the State Land Office's turn to ask their questions of this witness presented by Namoga. Mr. Grazer, I see you on the screen here. Do you have questions of Mr. Sporich?
Good morning, Madam Hearing Officer and Commissioners. First, let me confirm that my microphone is now working.
It is.
I apologize for that. It was working earlier in the day yesterday, and I don't know what happened. I have a few questions for Mr. Sporich.
Go ahead.
Good morning, Mr. Sporich.
Good morning.
So on slides 9 and then again on 35, you referenced paying quantities. Do you have a definition of paying quantities that you propose or that you use?
Madam Hearing Officer, can we pull up the slides if we're going to talk about them, please? We're glad to help Mr. Grazer.
Thank you. I
Yes.
appreciate it. I wasn't able to locate it. As you
You
know, I'm
bet.
filling in. And Madam Hearing Officer, when I'm done with cross-examination of this witness, then Mr. Moore will take back over.
That's fine. I think Mr. Everhart is going to help out here with the slides.
Thank you.
Mr. Grazer, do you mean the direct slides or the rebuttal slides?
So I believe it was the direct.
Okay, we'll start there, and if we need to switch, we can do that.
Thank you.
And just to clarify, it's slides 9 and
Let's
35?
start with 9. Yes, please.
Okay.
Yeah, so this does towards the middle of the third paragraph.
Correct. I
you-
see what you're saying.
Okay, fair enough. So my question is, do you propose a definition of paying quantities?
As for NMOGA, I can't speak for NMOGA for their definition that they would want. I could tell you what my interpretation of paying quantities would be is revenue exceeding cost on a lease basis, not a well basis, but over a lease.
And
it's over a certain period of time.
right, okay, and what period of time would that be?
I don't have a specific number of months that I would propose.
Have you been involved in paying quantity disputes?
Yes, I have.
And what sort of time frame were you arguing for in those disputes?
It's been anywhere from 12 to 24 months.
And then I should ask what parties you were representing.
Chesapeake Energy.
Okay. Were you present for Mr. McGowan's testimony yesterday?
Yes, sir.
And did you hear his ideas and his concepts on paying quantities?
I don't recall his commentary on that specific topic.
Okay. Do you recall whether you had any particular agreement or disagreement with his testimony?
No, nothing. Like I say, I don't remember anything, so nothing jumped out one way or the other of either being a striking yes or a striking no.
All right. And are there any other factors you would look at? I know we have, general cost and revenues. Are there any specific factors you would look at in determining paying quantities?
Yes, we'd look at the history, operational history as well. Obviously, as we've mentioned previously, shut-in purposes for offset fracs, well downtime for midstream issues, things like that, things of those nature, mechanical issues with the well. I think you have to take all those under consideration.
Thank you. I appreciate that. You also in your testimony, you spoke about waste, and I'm going to see if I can share. Yeah. Are you familiar with New Mexico Administrative Code 1915-28B3?
I'm reading it right now. I've read it before.
Take your time. Take your time.
Yes, I see it.
Okay, so this requires a well that hasn't produced in 12 months and is not placed in temporary abandonment to be plugged within 90 days, correct?
Yes, it appears so.
Would you consider application of this rule to be potentially waste?
Not necessarily. you have the ability to place it into, there is an option to place it into an approved temporary abandonment status.
All right, well, so let's assume a hypothetical in which, for whatever reason, you don't meet the requirements to place it in a well in temporary abandonment status, and it's a well that still may have some potential or some reserves. If you're required to plug that well, would that potentially result in waste?
I guess if it doesn't meet the standard for or approval for approved temporary abandonment, and yet there's still production that's available, I would say that constitutes waste.
Okay, so you agree with me that current OCD rules could result in what you would consider waste then, right?
Under that hypothetical.
Okay. Thank you, Mr. Sporich. Thank you, Madam Hearing Officer. I have no further questions.
Okay, and thank you, Mr. Grazer. Let's see. I don't believe we have Ms. Nanasi with us. Mr. Maxwell, do you have any questions?
Can you hear me?
Yes.
Hey, thank you. No questions.
All right, thank you. Mr. Rankin, do you have questions of Mr. Sporich?
I have no questions for Mr. Sporich. Thank you, Madam Hearing Officer.
Thank you. I think EOG is monitoring, but no questions. Mr. Cloutier.
No questions, Madam Hearing Officer.
All right, Mr. Suazo, do you have redirect?
I do, Madam Hearing Officer. Give me just a second to get set up here. Due to the topics on cross, we're going to show some demonstratives for purposes of guiding the questioning.
What were these provided previously?
We can provide them. I mean, they're just for discussion. It's all public information. Yeah, this is from the New Mexico Supreme Court website.
We object to this as not being provided in compliance with the hearing or the scheduling order and hearing order.
Yeah, was supposed to be uploaded to Center Stack or sent around somehow by email.
Okay, I mean, this is all public information on the website. Anybody can look at it.
Right, but the fact that you're going to use it as an exhibit.
Well, we're not going to submit it for the record. We're just using it to guide the questioning.
To ask the question, right?
Madam Hearing Officer, just to preserve the objection, I mean, this is all, we've got extensive testimony in this case about legal arguments, which was all fleshed out in the motion to dismiss and responses and can be covered in closing. So I just want to preserve our objection that counsel's trying to rehabilitate the witness through walking through canons of statutory interpretation. He's allowed to make this argument in closing.
Would that be a better place, Mr. Suazo?
I could make it in closing. Yeah, I'm glad to do that. Well, actually, let me ask this. So when we had our scheduling conference, we were told that there was not going to be a closing. So are we fine that there is going to be a closing?
So there's a distinction between an oral closing and a written closing.
Okay.
Because on the complex rulemakings, the commission doesn't just sort of gavel into deliberations as soon as we make the record.
Mm-hmm.
So I would invite you to make your legal arguments and your written closing argument.
I actually prefer to do it that way. Thank you.
Great, thank you. Can I turn then to the committee? Do you have questions
Let
then?
me just confirm there's nothing else
Okay.
that I want to ask the witness. I do have a few questions, and we're still going to pull up some documents that are already in the record for purposes of the versions of the rulemaking the applicants have proposed, if that's okay with any of the parties.
I won't object until I see it, Mr.
Okay, fair
Swat.
enough. Mr. Sporich, do you recall Mr. Tisdale asking you about your direct testimony and discussing a $200,000 blanket bond?
Yes, I do.
Have you reviewed Welk's original petition from June of 2024, which is filed on the commission's website?
Yes, I went back. It was under the June 2024 proposal.
Okay, let's pull that up. Can you see that on your screen?
Yes, I do.
In the highlighted portion, what does that say?
This is from the original proposal of blanket plugging financial assurance for $200,000 for 1 to 5 wells.
So just to clarify, that's Welk's initial proposal that they submitted in this proceeding?
Correct.
Thank you. Now, Mr. Tisdale mentioned that there's been a few revisions from applicants submitted for review. Do you know how many proposed amendments have been filed through this proceeding in total by all the parties?
Yes, it's so far it's been 10 proposed amendments.
Okay. And so the red line attached to your direct testimony that Mr. Tisdale and Mr. Hall were asking you about yesterday, do you know what date that was filed?
What'd you say?
Do you know what date that was filed on?
Filed on August 8th.
Okay. And was there a version on that you are aware of?
Yes, it was the this third errata.
Okay. Do you know how many versions the applicants have filed in total?
I believe it's 3 additional ones for a grand total of 6.
Okay. Thank you, Mr. Sporich. No further questions, Madam Hearing Officer.
All right, thank you, Mr. Swazo. Commissioner Mpoma, do you have questions of Mr. Sporich?
Yeah, there are a lot of legal discussions here, so I'll leave it to the lawyers. Thank you. No questions.
All right, Commissioner Bloom.
Mr. Sporich, thank you for your testimony. I do not have questions either today. Thank
Awesome.
you.
Thank you.
And Chair Chang.
Most of these issues have been covered, but so I do want to explore one assertion in your direct. I believe it's starting at paragraph 130. If you're welcome to pull that up. It's a longish paragraph, but towards the end of that paragraph, you've got a sentence in there that says the OCD may not enforce or condition operator registration on compliance with laws outside of New Mexico.
Did you say paragraph 130 of?
130 of your, I believe this is your direct.
Correct.
And we can pull it up for the witness so you can see if that's fine.
Please. It's on page 30. The paragraph starts on page 36, but I'm looking at a sentence on page 37.
Okay, I'm reading it right now.
Sure.
All right, I have it and I've read it. Could you repeat your question, Commissioner?
Okay. Sorry, let's go down to 131. I had scribbled over where it says 131, so I lumped 2 paragraphs together. My apologies.
Okay, sorry.
If you want to scroll up just by a hair so we can see that the top of that page though anyway. Okay. So let's start at the middle of 131. There's a sentence that starts, the OCD may not enforce or condition operator registration on compliance with laws outside of New Mexico. Did I read that correctly?
Yes.
Okay. And then at the top, and the reason that you give is actually in the previous paragraph at the top of this page here, violates the principles of state sovereignty and federalism. Is that correct? That's the reason for the conclusion is that
Ye-
OCD may not.
Yes, that's the argument.
Okay. You're licensed to practice in Texas, correct?
Correct.
Okay. Texas rules of professional conduct, and you can take this as hypothetical, not trying to introduce facts, not in evidence here, but the Texas attorney rules of conduct requires an attorney who has been disciplined by an other jurisdiction or a federal court or a federal agency to notify the disciplinary counsel within 30 days. Would those rules of professional conduct for attorneys to report out-of-state violations or disbarment also violate principles of state sovereignty and federalism? And if not, how would you distinguish those requirements to maintain a certification either with a bar or the certification with OCD here?
Well, the first part of that is no, I do not think that it impedes the bar disciplinary. I don't think that affects state sovereignty rights between New Mexico and Texas. I think that's been well established throughout the country. What we are saying here is from a regulatory standpoint, from what the Act has provided previously, it is my belief that OCD getting their powers by a limited grant from the New Mexico Oil and Gas Act, I don't think that it shows that they have the ability to enforce other states' regulatory environments. I think we've mentioned also previously, or somebody has mentioned previously, there could be minor infractions that come up, and I know that that's not your concern right now, but
Sure.
it could be one of those ones where how do you report and how does that work from a standpoint where it might be a paperwork situation versus an actual violation that I think what the commission is trying to get after. But again, that's dealing with a different state and their rules for enforcement from an environmental standpoint under the New Mexico Oil and Gas Act.
Okay, so your concern is limited not to constitutional or sovereignty or federalism concerns. Your concerns is limited to whether or not the state are particular enabling statute. That's how you would distinguish those situations. Is that
no? I think it also has to do with state sovereignty as well. I just think that there is a distinction, and I'm not articulating properly, but I do think there is a distinction between the bar, as you mentioned,
right,
disciplinary bar, and enforcing environmental rules.
Right. So help me understand the distinction, or how you would distinguish those things, because isn't it both situations where we're looking at certifying somebody as being in compliance with their responsibilities in both situations?
Yes, I could see that.
Okay. I think most of the other issues have been. Let me turn to a slightly different issue, and hopefully I'm not beating a dead horse here, but we do certainly, while I'm here, I certainly want to track our enabling statute as closely as I possibly can. So we certainly appreciate your analysis and advice and your contributing to the conversation to make sure that the commission is tracking the statute as closely as we possibly can. I want to explore the word sufficient a little bit in NMSA 7214A. You quote it on page 6 of your rebuttal. Or at least I think you slightly paraphrase it. OCD must set one well financial assurance, quote, in amounts determined sufficient to reasonably pay the cost of plugging. We've heard testimony here that wells cost $163,000 to plug. So Would the applicant's proposal of 150,000 be sufficient? Would it violate the statute for us to adopt a number below 163,000?
I think that if I'm reading it as a whole, sufficient to reasonably pay. And we've also heard testimony too, and in my previous experience at Taprock, we plugged wells for much less than that. So nothing in the statute here says that it's only sufficient to reasonably pay for OCD. It doesn't say anything specific to just OCD. It just says sufficient to reasonably pay. And I think that if there's outside information that says that it's reasonable to pay $65,000 to plug wells, I think that has to be taken into consideration too.
So I guess I'm struggling a little bit here because it seems like we're reading into the statute a word of average, because it doesn't say that. It also doesn't say, I guess I'm struggling with the word sufficient here. Sufficient on average. And of course, it seems like everybody is arguing some sort of average. People just don't seem to agree on what that average should encompass. But it seems like the statute doesn't actually say average. Don't we have to look at the most expensive well to make sure that we are always sufficient to cover the cost of plugging? The statute, I mean, I'm looking at this. Thank you for whoever pulled up this lovely rainbow, because I don't see the word average anywhere in here. And I do want to, as you cautioned, track the statute down to the letter.
Right. I still, my opinion is it goes together with the reasonably pay. It has to be reasonable.
In the reasonable world. Fair enough. Okay. I think I will leave it there. Thank you very much. I appreciate it.
Thank you, Commissioner.
Any reason not to excuse Mr. Sporich? No, thank you very much, Mr. Sporich. We're less than 45 minutes into our day. Ms. Felix.
I apologize. Could I ask one more question of the previous witness?
Oh, all righty.
Don't have to play yet.
And if I could have that rainbow statute again, that'd be very helpful.
More costs.
Can we call it Rankin's Rainbow going forward?
Yes, yes. You now have a statue named after you, Mr. Rankin. So I think there's been, extensive discussion about this and highlighting of this particular provision that's so crucial to our rulemaking here. And I'm reading it here. Such categories shall include, and it gives 3 separate categories. And people have already debated the definition of the word such till I think we're all blue in the face. But I guess it seems like, and tell me if I'm interpreting your brief wrong. It seems like in certain sections of your brief, there is an assumption that it's lest I reopen a different and/or gate, that each of these categories are mutually exclusive. I'm trying to figure out whether or not, as a matter of policy, we should go there different. Just trying to figure out my statutory boundaries here. Is there anything in that statute that says that these categories can't be cumulative? I mean, because it says and, right? Blanket bonding, at the end of the green, you've got a comma.
Right.
At the green end of the blue, you've got a comma. And one well plugging financial assurance. I'm trying to figure out where in the statute it requires us to, and maybe we should anyway, as a matter of policy, not debating that yet, so don't light anybody's hair on fire yet. But does the statute allow us to require, after creating multiple categories, to potentially have an operator fall into multiple of those categories?
Well, I think the one thing I'm looking at, Commissioner, is how it is structured. And I think that there is, you can see the kind of the green, the blue, and the purple.
Mhm.
I see that as that last comma that's in there. That's the penultimate comma that's in this provision.
Sure.
And I think that bookends the financial assurance categories that's there. And I think limiting these categories, I don't know. I haven't read it necessarily to say that you could combine these all together. However, I think if you do combine them all together, like I think you're proposing.
Just trying to figure out
Yeah,
what the
I think-
boundaries of the statute are. Yeah.
Yeah, I think if you put them all together, I think it then goes above this blanket $250,000 that we've talked about previously. But it's a process I haven't necessarily thought yet of, is this if we are saying that these are the only three limiting financial assurance categories, can they not be stacked on top of one another? I think plain reading of it, I don't think that provides that, but I can see where someone could make that argument.
Okay. And that may be terrible policy, but I'm just trying to figure out whether or not the statute is clear about whether or not these whether they're, and or opening up yet another and or debate here. But I appreciate your answer. Thank you.
Thank you.
Righty, we're welcoming Ms. Felix to the witness stand. Would you spell your first and last name, please?
Yes, Andrea, Andrea, last name Felix, just like the cat, F as in Frank, Elix.
That's the male version of my name. Do you swear or affirm to tell the truth?
I do, yes.
Thank you very much. Mr. Swazo.
Thank you, Madam Hearing Officer. Good morning, Ms. Felix. How are you doing today?
Good morning. I'm much better than the last couple of days. I'm recovering from a head cold.
Excellent. Well, glad to hear it. Hope you have a speedy convalescence. We have your slides up there. Yes. Okay. Can you please state your name and your role in this proceeding?
Yes, my name again is Andrea Felix. I'm the Vice President of Regulatory Affairs for the New Mexico Oil and Gas Association. And my role in the proceeding is to bring the industry perspective from the trade organization side of things as part of the regulated party in these proceedings.
And what is your professional background and experience in the oil and gas industry?
So I've worked in the industry for over 2 decades, specifically in New Mexico, as a surface landman and specializing in operational, regulatory, and policy issues throughout my career. Purpose of my testimony today is to highlight the operational and industry-wide consequences of the proposed amendments, to provide an integrated industry perspective to the portions of the proposed rules that are unworkable for industry, and to recommend practical alternatives that maintain protection without undermining New Mexico's oil and gas sector.
And did you file rebuttal testimony in this case?
Yes, I did.
And what is the purpose of your rebuttal testimony?
To respond to the applicants and OCD's remarks to our submitted direct testimony.
Now let's move to your slide 3. Can you explain to the commission NMOGA's overarching concerns with applicants' testimony and proposals?
So the overarching concerns that we have is, as we've learned through the proceedings, so there's been a lot of new information learned, right? I think we've all learned a lot over the last 2 weeks. But as the applicant's original application to industry, there is mischaracterization on the data on orphan, marginal, and active wells, and the reliance on the inflated costs from OCD's procurement practices that were provided. But again, as we've learned through the proceedings, it seems like we've got some corrections that can be made and some discussions to be had.
In your rebuttal, what is your response to the way applicants and OCD address plugging costs?
In my rebuttal, the plugging costs that applicants and OCD are relying on are costs that were incurred by the division, right? Part of what the message that we have here, if we can work on helping to enhance and correct some of the procurement processes, the way in which the division, who I believe is single-handedly one person trying to manage the orphan well program, we'd be able to better come to an understanding and an executable program. And that's what my rebuttal is about. Oil and gas industry, they drill wells, they plug wells, they reclaim wells. So while having the applicants and OCD being open to getting insight on how this is done, because I think we've established over the last 2 weeks, industry can do it a whole heck of a lot cheaper. Well, sharing those experiences and those best practices on how industry puts together a program so that potentially the division could create a systematic program themselves, which would then just better all of us.
Have you received or have you reviewed the LFC report that applicants rely on in this proceeding?
Yes, I have.
And what is your interpretation of how applicants, have utilized the LFC's report?
I would say that applicants have used it to how do I want to say this? They've relied on it to state their platform when it comes to costs and execution of the program. I think all of us who have read the report have very many different interpretations of what that report says. But I think at the end of the day, what we can all agree upon that the report told us is that there needs to be some changes. And I think those changes could come from a unified front working on the procurement, going out to bid to industry-wide vendors so that OCD isn't just constrained to 1 or 2 vendors. OCD could potentially have 3 or 4 rigs running, 3 or 4 different programs running throughout the state. And that's a takeaway that I took away from that report.
Do you know whether the LFC report proposed statutory or regulatory changes?
They did, yes.
Okay. Let's move on to your slide number 4, where you discuss a definition for beneficial purposes and beneficial use. Ms. Felix, what is NMOGA's view on Welk's proposal to add a definition for beneficial purposes or beneficial use?
The biggest concerns that we have is it goes against the definition used for decades within industry. And so it ignores what beneficial depends on in terms of what we heard from Mr. McGowan of evolving technologies, markets, infrastructure, and geology. So the things that, every day there's technologies in whatever industry that we're in changing and improving and making things better. And so while looking at these wording changes, could hamstring what the industry could do to just continue to be a better developer in the state of New Mexico.
Okay. Now, as part of that definition, there's a phrase speculative purposes. Why does NMOGA oppose applicants' attempt to prohibit speculative purposes?
I think, again, it goes to the stifling and the hampering it could put on innovation as technologies improve, as learnings are learned, as new wells are drilled. We learn things every day, and while the new wells technology evolves every day, so does the technology for those wells that have been here for years. We've got operators that are in the business of, taking that old classic car and making it something new today. And my goodness, to stifle that innovation would just, I think, do a harm to the state and to the resources.
So with respect to this proposed definition, what is NMOGA's final position on this issue for the commission?
We would like, if the commission is inclined to adopt a definition that is so broad and flexible is not what we're recommending, right? But something to not constrain future beneficial uses, to essential to prevent waste and protect correlative rights, and give industry and those entrepreneurs the opportunity to bring that old Chevy, 1950 Chevy up to par.
All right, let's move on to your next slide, where you discuss presumptions of no beneficial use. Can you please explain the proposed presumption regarding beneficial use as you understand it?
As I understand it, applicants presume a well incapable of beneficial use if 90-day production thresholds are unmet within a 12-month period. And then that allows for, as written, a 30-day window to rebut that lack, specifies as to when the 30-day window begins.
What is NMOGA's concern with the 90-day 1-year threshold that is proposed?
It doesn't allow for the let me start again. It doesn't account for all those viable wells, right? And and not just a well basis, but also a lease basis, as we heard Mr. Sporich speak to earlier. So while individual wells stand alone and operate on their own, wells within a lease also kind of collaborate with one another. And so that needs to be taken into consideration as well.
Okay. And there's a rebuttable presumption framework within that proposal, with a 30-day window. Does NMOGA have any issues with that proposal?
Yeah, we believe that 30-day window lacks enough time for folks to, 30 days to get a plugging rig, to make sure there's equipment, crews, plans, get it approved from OCD is just not a long enough window. It also doesn't account for many, many viable wells. We've got members who have been operators in the state of New Mexico. Their great grandfathers started these companies. They are in the business and have been of operating these types of wells for generations already. And by reclassifying these wells, will essentially send these very legacy companies out of the state. And that's one of our greatest concerns.
Okay. Now, you've worked in the oil business yourself. Based on your experience, how do you think this presumption would affect reservoir and field management types of issues?
I think it would leave potential for waste and undeveloped resources, resulting in undeveloped and funds that would have went to the state, to the schools, to the children, to the funds that are now helping to provide for a 10-day extension through SNAP, the unified childcare credit that is going around, the state would be losing out in that.
Did you hear Mr. Arthur and Mr. McGowan's testimony in this proceeding?
Yes, I did.
And do you recall whether they gave any real world operational examples of, well, you know what, let me move on to the next question. I don't like that one. Now that I've said it aloud. Sticking with your slide 5, are there concerns with federal lease terms or other regulatory conflicts that NMOGA foresees?
Absolutely. And that's why, in my comment earlier, that the introduction of the lease parameters and definitely need to be taken into consideration too, because as operators are bound by their lease terms and planning portfolios and planning projects, they have to be cognizant of those lease terms. And so I think it is our duty through these proceedings to also take that into consideration.
Now, have you heard Mr. Sporich's testimony and read his testimony?
Yes.
Does NMOGA believe that the commission has the authority to adopt this presumption?
No.
Let's move on to your slide 6. Ms. Felix, can you tell the commission what NMOGA is recommending regarding this proposal to create a presumption of no beneficial use?
Yes. If NMOGA recommends, if the commission is inclined to adopt Welk's proposal, that it should only apply to extended periods of time of inactivity, such as 5 years.
Okay. So we finished with the beneficial use. Let's move on to the financial assurance portion of your testimony, starting with slide 7. Ms. Felix, do you know what Welk proposes with respect to the changes to Rule 1915-89A regarding acquisitions and financial assurance?
Yes.
What are NMOGA's concerns with this proposal?
Our concerns with this proposal is that this would grant OCD the authority to act as the gatekeeper over acquisitions and transactions in the state in regards to oil and gas.
Okay. And does NMOGA rely on Mr. Sporich's testimony and opinions in that?
Yes.
What does NMOGA recommend that the commission do with this proposal?
Our recommendation is that the OCC reject this provision. If the commission does explore it, recommended changes are to limit application strictly to operational approvals, distinguish ownership from operations, define clear triggers for financial assurance, and engage stakeholders in designing a workable framework.
Now, it seems like there's a pre-transfer element to this based on the language. Does NMOGA have concerns about the impact of this pre-transfer requirement?
Yes.
Okay. Let's move to slide 9. Oh, sorry. Does NMOGA have any ideas on real-world consequences for the industry if this proposal is adopted?
Yes. So as Mr. Arthur and Mr. McGowan testified earlier, Welk's proposals cause significant administrative burdens, budgeting complications, impediments to flexible development, which would essentially be a waterfall. Bottom line of, where our concerns are is that OCC should reject the proposals as drafted because they constitute regulatory overreach, create heavy administrative burdens, especially on a well-by-well tracking basis. And again, I'm going to say it again, that goes back to the lease. implications as well. So taking the look on a well by well doesn't answer and dot the I and cross the T when it comes to lease production. And it would inhibit asset transfers, particularly for depressed marginal assets. NMOGA believes that legislature should make statutory changes before these rules can be adopted.
All right, let's move on to your slide 10, where you discuss the proposed changes for active wells. What changes do applicants propose for financial assurances on active wells?
So the current proposal is 150,000 or a 250 blanket bond, regardless of the number of wells in a portfolio.
Okay. Have you also, next slide, please. Have you reviewed applicants' proposals for inactive and temporarily abandoned wells?
Yes, I have.
Do you know what those require?
Yes, Welk's proposing the 150,000 bond per active well, 250,000 blanket bond regardless of the well count, and an additional 150,000 bond for marginal wells.
What is NMOGA's position on these proposals?
As Mr. Sporich testified, OCD's statutory authority only allows financial assurance amounts sufficient to cover reasonable plugging costs. And again, as we've uncovered through these proceedings, I think there's room for conversations on what these reasonable costs are. Welk's proposal removes depth as a factor and sets requirements disconnected from actual costs exceeding statutory limits.
Okay. Now, do you think the existing rules already address non-compliance in this area?
I do. And I think with the existing rules and with a fully functional orphan well program, with the fully functioning use of the reclamation fund, we may not have as big as a problem as what was originally brought forward to these proceedings. As we've learned, numbers are changed, cost estimates have changed. What is an orphan well? What does the list look like has changed. So I think there is absolutely room to show that the mechanisms that are in place and have been for many years, modernizing those and having a fully executable program could 100% work. And I will go back to the here and the now, right? Deputy Director Powell brought up an incident over the weekend, and he said that 2 operators raised their hands and helped through that. And that's where operators are today. We're here talking about issues and wells from many, many years ago, while the rules that are in place now and the enforcement the OCD currently has by utilizing the enforcements of the regulations and the assurances in place will help us to ensure we don't get there in 50 years from now, but also help us address the problem that we're facing today once we're able to quantify what that problem is.
Can you please tell the commission what NMOGA recommends, especially if there's any sort of alternatives?
Yeah. So our recommendation would be to retaining a fixed tiered blanket structure tied to well counts and statutes. If revisions are made, we would recommend preserving the blanket bond options, use a risk-based approach tied to compliance history, apply prospectivity, not retroactivity, and avoid expanding OCD's authority beyond statute.
Now let's move on to your next slide, 13, which is titled Incomplete Blanket Financial Assurances. Ms. Felix, are you aware under the current rules what happens if a blanket bond does not cover certain wells?
Yes.
Can you please explain what the current rules require?
The current rule requires operators to post a single well bond or replace it with a blanket bond for their full portfolio.
Are you aware what Welk is proposing under this rule change?
Yes.
Briefly, could you explain what that is? Or I guess you already.
I think I've already done that.
What's Namoga's position on this proposal?
I think again, based off of the legal outreach that Namoga has undertaken with our legal team, that it lacks the statutory authority to make those changes. I think another important item to raise is that it is redundant to the existing regulation that's already in place and provides for cure under coverage there.
Okay. What are Namoga's recommendations to the commission with respect to this proposal?
If the commission feels so inclined to amend, the rule should expressively allow for replacement of blanket bonds to cure under coverage, preserve operator choice between single well and blanket coverage, and include a clear transition period for securing replacement coverage.
Ms. Felix, does your testimony address the consumer price index?
Yes, it does.
And do you know what applicants are recommending with respect to the CPI?
Yes, yes, I do.
Okay. What is Namoga's position on applicants' proposal to adjust based on CPI?
Our concern is that it introduces volatility and uncertainty into capital planning. All operators plan in different mechanisms. Smaller operators plan 3 to 5 years out. Larger operators plan on different frequencies. Portfolios look very different. And so this type of basing it on a CPI would introduce ambiguity and also could disrupt long-term compliance and financial strategies. It'll also add not only to be a burdensome task on the operator, but also for OCD to administrate it as well.
Now, what is Namoga's recommendation to the commission on the proposal to adjust based on CPI?
So here again, we recommend that the OCC reject Welk's proposal and suggest a 5 to 10-year review intervals tied to a tier plugging costs data, risk profiles, and bonding market conditions, not broad consumer inflation indexes.
All right, let's move on to your next slide, slide 15, which deals with marginal wells. Ms. Felix, are you familiar with applicant's proposed definition for marginal wells?
Yes.
Can you please explain your understanding of what that is?
Welk proposes a two-pronged test to identify marginal wells less than 180 producing days and less than 1,000 barrels over 12 months.
And are you aware that this proposed definition is related to their financial assurance proposals?
Yes, I am. I will also add, though, as we've gone through the proceedings and we've heard from other parties, we have heard that there is some openness to variable of these numbers. And so Namoga is very interested in having those conversations and seeing what we can all agree upon as these proceedings unfolded.
Okay. Slide 16. So taking all what you just said into account, what is Namoga's recommendation to the commission for marginal well financial assurance?
So again, just adopting a risk-based approach rather than categorical thresholds, preserving and improving the blanket bond option, clarifying the administrative mechanisms before pre-well assurances, eliminating the arbitrary 15% trigger, and convening a stakeholder group to share workable bonding rules.
So you mentioned earlier that you have reviewed the LFC report. Do you know whether the LFC report contains a definition for marginal well?
Yes, it does.
Okay. And is it different from what applicants are proposing in this proceeding?
Yes, it is.
Okay. In your view, how are applicants characterizing marginal and inactive and temporarily abandoned wells?
In my view, I mean, they're characterizing them, at a high risk level. And so that the reality is marginal doesn't equal high risk, right? And I think that's what we're here to try to tell that story.
Did any of NMOGA's witnesses kind of explain that to the commission, to your recollection?
Yes, I believe, and again, remember, I've had a head cold the last couple of days, but I definitely heard that with Mr. McGowan yesterday.
Okay. Does NMOGA think that the commission has the authority to create marginal well financial assurance categories?
No.
Let's move on to your slide 18, which discusses wells to be properly abandoned. Are you familiar with what the current rules require for wells to be properly abandoned?
Yes.
Okay. And do you know what changes WELL proposes to this rule?
Yes, I do.
And what are NMOGA's concerns with the proposal?
Really, that 30-day window, as I stated earlier, it's very unrealistic to think that an operator can contract out a plugging crew, get the approvals from OCD, ensure that there is the required workforce, and there's so many different factors, weather, landowner approvals and notifications. And I think we've also heard that same struggle from OCD as they're planning plugging on their side as well.
What is NMOGA's recommendation to the commission on this proposal?
NMOGA urges the commission to adopt alternative language. In our NMOGA's pre-hearing statement, Exhibit A, we provide practical enforceability without sacrificing environmental protection.
Okay, let's move on to your slide 19. Are you familiar with the current approved temporary abandonment rule?
Yes, I am.
Okay. Are you familiar with what applicant proposes to the ATA requirements?
Yes.
Okay. What are NMOGA's concerns with their proposal?
A concern that we have is the requirement for disclosure of sensitive information. While we do know that there is a mechanism for confidential information, there again, submittal of confidential information into OCD's house again adds another layer of administrative oversight, which as currently staff could pose an issue for OCD.
Did you hear Mr. Sporich's testimony on that statute that is intended to protect confidential information?
Yes, I did.
Do you share his concerns with whether it's stringent or not stringent enough?
Yes.
All right, let's move on to slide 20, which deals with approved temporary abandonment to 1915-27813. Ms. Felix, do you know how temporary abandonment is defined currently?
Yes.
And do you know how WELC proposes to change this definition?
Yeah, their proposal requires showing of beneficial use.
Okay. Does NMOGA oppose this change?
Yes.
Can you explain why?
Really just to avoid the confusion of, I don't think that we've all aligned on what beneficial use is. And again, going back to my old Chevy car example, it is for that very reason.
Okay. And what is NMOGA's recommendation to the commission on this proposal?
To reject the proposal as submitted.
And if the commission instead decides to proceed with adopting some sort of change here, what is NMOGA's recommendation?
A more tiered approach.
Okay, let's move on to your testimony regarding expired temporary abandonment. Are you familiar with Welk's proposal regarding expired temporary abandonment?
Yes.
Did any of NMOGA's witnesses raise any legal concerns with the proposal?
Yes, Mr. Sporich did.
Okay. And based upon Mr. Sporich's testimony and feedback from NMOGA members, what is NMOGA's recommendation to the commission?
Again, to reject these changes to avoid uncertainty for regulators and operators. So not just for industry, but for regulators and OCD themselves. OCC should rely on existing provisions which already addressed approved temporary abandoned expiration and renewal procedures.
Okay. Let's move on to your slide 22, changes of operator. Are you familiar with the current change of operator rules and how applicant proposes to change them?
Yes, I am.
Okay. What are NMOGA's concerns with applicant's proposal?
The current proposal lacks the materiality of thresholds for noncompliance, inviting arbitrary enforcement and room for interpretation, right, from the regulator, creates retroactive liability via affirmation-based disclosures, regardless of the operational role, conflicts with fiduciary and corporate governance duties, as well as OCC lacking the statutory authority to require compliance with laws of other states.
Okay, so I guess then based upon that feedback from an operations standpoint, what problems arise from requiring a P&A plan at the change of operator stage?
Well, it's very pre-decisional. You know, you're putting a plan together for a well before that well has died, essentially. Putting that plan together at the time when the well is not ready to be plugged could be misconstrued by some that if a plan is there, that well is ready to be plugged, and it is not. So I think aligning with the practicality of having that plugging plan when the well in the here and the now is more practical, not only for industry, for OCD, but also for members of the public, because one could misconstrue and think the well is at its end of life if that plugging plan is submitted and on record at OCD.
Now, also part of this section, applicants propose conditioning registration in New Mexico with compliance in other states. What is NMOGA's position on that?
To strike that provision, mandating the out-of-state compliance in its entirety. We oppose Welk's Section B changes and recommend replacing the 25% affiliation test with a control-based test. And if any showing of P&A capacity is required, adopting a very clear objective standards would be our recommendation.
Does NMOGA recommend, well, actually, I'll move on to the next question. I think you already covered that. On your next slide, slide 24, dealing with 1915 9.9C and proposed new subsection E. Do you know what the current rule 9C allows?
Yeah, currently the denial for non-compliance or under ACOI with no compliance schedule.
Okay. And what are NMOGA's concerns with applicant's proposal to change section C?
Again, out of compliance in other states, the 25% holder was within 5 years, not properly registered with New Mexico Secretary of State, cannot meet the P&A requirements, transfers prohibited, transfers of non-compliant wells unless made compliant.
Okay. Did you hear Mr. Arthur and Mr. McGowan's testimony on this issue?
I believe I did, yes.
And what is NMOGA's position based upon the testimony they've heard in this proceeding?
Between Mr. Arthur and Mr. McGowan, verifying compliance across multi-jurisdictions and legacy entities is often very impossible. Proposal will heighten due diligence burdens, delay deals, raise costs. Sellers cannot realistically certify a buyer's multi-jurisdiction compliance. And ultimately, this is going to add an additional burden onto the division.
Okay. And if the commission decides that it does want to proceed with this proposal and adopt this sort of screening, what is NMOGA's recommendation?
NMOGA would recommend that the commission takes a balanced approach to this very provision, so not to deter prudent operators coming into New Mexico.
Okay. Now let's move on to your next slide. There's been a lot of discussion about NMOGA's involvement in this rulemaking. Do you recall listening to the testimony of Welk's witness, Thomas Alexander?
Yes.
And do you recall him saying that it was regrettable that NMOGA did not sit down with OCD and applicants to discuss these proposals?
Yes.
What is your response?
So I've been waiting for this time. We are not here to throw stones. We are here because a rulemaking petition was filed. But I do want to give some clarity and some understanding as to how and when NMOGA was introduced to the potential petition by the applicants. Our CEO received an email from Ms. Tanis Fox on a Saturday advising that the applicants were considering some rule changes and asked if we would like to sit down and have a discussion. So thank you for that, Ms. Fox. We did respond back. Missy works 24/7. We did reach out as our protocol requires us to, conferred with our board, reach back out to Ms. Fox. On Wednesday of that following week, Ms. Fox graciously said, we can meet with you guys on Friday. So we pulled our resources together. We met with them. At that point, they were prepared verbally to let us know of their plans. They were not prepared to show us anything in writing. We did ask if we could have an opportunity to before they petitioned. We were not guaranteed that we'd have that opportunity, that as planned, they were planning to petition within the next week. But they would be open to conversations. So we were appreciative of that. However, after that meeting, not having anything to take back to our members puts us in a really, peculiar spot because there's no decisions to be made, right? We immediately, as soon as the petition was filed, we sent that out to members, and not representing just one company and representing an entire industry. My boss, Missy, has 240 members who are our bosses, right? And so getting that trade organization membership buy-in and opinions is a huge undertaking. As we've listened over the last few days and understanding now that that the applicants and their witnesses have been working together since 2023. I mean, that just shows right there that it is a huge undertaking and it does take a great amount of time. We weren't given that amount of time. We weren't given that luxury. Once the petition was filed, all parties that had entered an appearance, including OCD, did have a meeting. OCD communicated that they were going to be providing substantive red lines. So NMOGA's members waited for the OCD red lines so that we were working off the most current version of the proposed rules, right? We understood we were going to get those by November. Ms. Fox graciously reached out to all the parties, asking for conversations in October. And while we did have council attend one of those discussions, without OCD's changes that had been reflected through the parties, we had nothing to take back to add value to those conversations. So fast forward to February of this year, we received OCD's revisions, and then subsequent to that, a couple more. Long story short, it's not an excuse, but it is the reality that trade organizations live within, and that is being the voice for many companies. Instead of having 240 interveners in the rulemaking process, we try to bring consensus. Would we have loved to have had the time? Yes, but we would have had to have asked for a delay in the proceedings. And after the delay that had already been, undertaking, we felt it was best to take what we were given and come to hearing. Now, listening to applicants' witnesses, listening to OCD's witnesses, NMOGA, we're very happy to have those conversations now and to have that reflected onto the things that, as I've stated before, have been positioned that there's some room for discussions here. I think we can get this right, and we want to. So I just would like to make sure that, yes, applicants did reach out, but it was not in a true manner of truly getting feedback before petitioning before the board.
I think you covered everything I was going to ask you on that point. So thank you for that. Let's move on to the next slide. Now, this slide covers the usage of guidance documents and forms. What has NMOGA discovered about OCD's use of guidance documents and forms?
So as we were working and putting together and researching, we did discover that since 2017, the division has already been enforcing a portion of the proposed amendments to 1915-9A NMAC and 1915-5-9 NMAC, which inserted the requirements specifically onto the C-145 form. Without any statutory or basis for doing so.
And why is NMOGA concerned about this?
It's really the concerning part for us is that because the division has already been making law through guidance and forms rather than through regulations approved through the commission.
Okay. And how does this practice from the division connect to applicant's proposal in this case?
Well, applicant's proposal includes this language almost verbatim. OCD is already requiring it on the C-145 form. So why is this rulemaking even needed if it's already been enforceable on industry over the last 8 years?
So if they've been enforcing it for years and it's actually in the proposal that's in front of the commission, what does this, underscore in your opinion?
I mean, it begs the question to members and to NMOGA of, are there other forms that we are already complying with that have not gone through the correct statutory changes for enforcement and authority?
And if they've already been doing this, what does that tell you about the proposal before the commission?
Again, is there a need?
What is NMOGA's recommendation to the commission on this issue?
NMOGA's recommendation is this item is not needed, to reject it.
Now, let's move on to your concluding slides here with the time that we have left. Starting with slide 27, what is NMOGA's recommendation?
NMOGA's recommendation at the time for the commission is to refrain from adopting any of the proposed amendments at this time. And I will preface that with, again, we've learned a lot through the last 2 weeks. I believe on all parties have come to an understanding of where each other is coming from. And there is an opportunity, as the commissioners have stated, for conversation to try to align.
Okay. Moving on to slide 28. I know these were your recommendations coming into the proceeding, and I'm going to give you the opportunity to walk through them and build in any other commentary based upon what we've learned over the last 2 weeks. So please proceed with your first recommendation.
Okay, thank you. First recommendation, again, is to reject the proposals beyond statutory authority. The commission should decline amendments that exceed its authority under the Oil and Gas Act, such as creating new bonding categories for marginal wells, imposing CPI auto escalators, or conditioning transfers on multi-state compliance. These provisions are legislative matters and not proper for agency rulemaking. Number 2 is to preserve the risk-based and tiered bonding structures, retain the current system of risk-based individual well bonds and tiered bonds tied to depth and risk factors, rather than adopting the flat $150,000 per well requirements. This framework would reflect actual plugging costs, statutory caps, while preserving flexibility. 3 would be to provide compliance flexibility. At a minimum, remove unnecessary cross-references, add compliance grace period for newly acquired assets, and recognize exemptions for temporary non-compliance. These refinements keep the framework workable and consistent with market realities. 4 would be to temporary abandonment as a conservation tool. Retain the current temporary abandonment program, while already provides oversight through mechanical integrity requirements and renewal. Reject arbitrary time cutoffs, adjudicatory extensions, or burdensome documentation demands that would make TAs unworkable in practice. Number 5 would be to reject presumptions on no beneficial use. Production or injection thresholds should not be used to define beneficial use. The commission should preserve case-by-case discretion, recognizing beneficial purposes such as lease preservation, reservoir management, future recompletions, and field development planning. Number 6 is to reject a new marginal well definition. A new definition misclassifies viable wells and injecting investment uncertainty. If the commission considers such a definition, it must clarify how it would be applied and whether it would automatically trigger heightened bonding requirements. Number 7 is to reject proposed waste prevention changes. The amendments to waste prevention should be rejected as they are unnecessary, impractical, and duplicative of existing protections. And number 8, operator registration and change of operator. Again, reject, or at a minimum, substantially amend new requirements that would tie registration or transfers to multi-state compliance, affiliations of 25% owners, or vague standards like substantial risk, limit to review material final violations in New Mexico, failures to meet New Mexico bonding requirements, and specific well integrity findings. 9, and expand use of targeted enforcement tools. Rather than discarding ACOIs, OCD should refine and expand them.
Slow down, Ms. Felix.
I'm sorry. To prioritize highest risk wells with enforceable milestones, while allowing lower risk wells to be managed under phase schedules. 10, recognize and utilize the reclamation fund. The reclamation fund, supported by conservation taxes, should remain our central part of New Mexico's plugging framework and should be considered alongside bonding changes. Adapt balanced alternatives. If adjustments are deemed necessary, NMOGA supports phase-in, risk-based assurance increases, light touch idle well certifications, periodic evidence-based reviews instead of automatic CPI escalators. Beneficial use definition. No new definition or presumptions of beneficial use should be added. If the commission considers such a definition, it would substantially amend to recognize beneficial uses beyond production or injection volumes.
Is this a good place for a short break?
This is the
Mr.
last
Spencer?
question and then she's wrapped up.
Okay.
Okay. It's the wrong slide. It's label 31. It should be a 13th. Anyway, actually that's it. So yeah, that's the conclusion of our questions. Madam Hearing Officer, NMOGA moves to admit to the record the direct and rebuttal testimony of Ms. Felix and the demonstrative exhibits that summarize her direct and rebuttal testimony.
All right, I'll pause for a moment in the event there are objections.
And I would make Ms. Felix available for cross-examination. And just to confirm that since she is a fact witness, those are limited to 15 minutes, I believe.
Yeah, I think, let's see here. It said technical, but,
We changed
oh, you
that.
changed it.
Yeah.
Okay.
on the-
Ms. Fox.
I think the whole of her testimony is in the nature of technical testimony, and she adopted the technical testimony of the other four witnesses. So I think we're entitled to an hour.
Yeah.
45 minutes.
Yeah. I think it is in the nature of technical testimony, requiring her professional experience as the director. Okay, so the exhibits are admitted. Let me speak those words. We do need a 10-minute break before we begin with cross-examination. So let's come back at 10:55.
In my neighborhood, there's been a fight before service.
Oh, yeah?
Yeah.
Which is around.
Okay, let's come back from the break, please. When we broke, Ms. Felix had finished her testimony, and we turn now to cross-examination. Ms. Fox or Mr. Tisdale?
Yes, thank you, Madam Hearing Officer. We're going to start, and Mr. Tisdale is just going to pass out one cross-examination exhibit to everybody. What's that?
So I can't believe he's taking this.
Good morning, Ms. Felix. I'm Tanis Fox. I'm a lawyer with Western Environmental Law Center, and I represent applicants in this proceeding. Do you have a copy of your direct and rebuttal testimony with you?
Yes, I do.
In reading your testimony, I was struck by the extent to which you referred to, cited, or otherwise adopted the testimony of other NMOGA witnesses. Do you believe that you cited to the testimony of the other NMOGA witnesses approximately 280 times in your testimony?
I don't know the exact count, but if you count it, I'll take your word for it.
So the extent to which any of that testimony upon which you relied has been undermined during the hearing, your testimony is undermined, correct?
I wouldn't categorize it that way. I would say that, you know, my testimony is to take what all of our other expert witnesses have brought together, in addition to the feedback that we receive from membership, and bring that to the hearing platform.
So, but the extent to which you relied on that testimony and the extent to which it's been undermined, your testimony is therefore undermined because you relied on that testimony, is my question.
Objection, that's overly vague. If she wants to talk about specific pieces of testimony, she can.
Okay, Ms. Fox, if you want to refer to something specific.
Thank you, Madam Hearing Officer. Ms. Felix, throughout your presentation, you referred in your testimony, and your lawyer referred in your testimony as to the proposals before the commission as Welk's proposals, correct?
Yes, well, applicant.
Yeah, and but you understand, don't you, that the Oil Conservation Division's proposals in this proceeding effectively mirror applicants' proposals, correct?
There is some overlap, yes.
Some overlap, or are the proposals nearly identical?
I would say that they have become nearly identical from what was originally proposed, yes.
They've been nearly identical since the parties filed their direct testimony, correct?
Since direct testimony, yes.
And you understand that there's a number of very significant proposals in Welk's petition and OCD's proposals that originated with OCD, correct?
That's correct.
And those proposals that originated with OCD include the presumptions of no beneficial use proposal at Part 25, correct?
That's my understanding.
And you understand that applicants and OCD had negotiations with OCC, and OCC supports that provision as well, correct?
That's my understanding.
And you understand that the provisions regarding marginal wells, there's 2 financial provisions proposed regarding financial wells in Part 8 originated from OCD, correct?
That's correct.
And then you also understand that with respect to the transfer provisions in Part 9, that applicants and OCD negotiate with OCC, and OCC supports those provisions in Part 9, correct?
That's my understanding.
So there's a number of parties here who are proposing amendments consistent with applicants in this proceeding, correct?
Yes.
On pages 5 to 8 of your direct testimony, you discuss your opposition to applicants and OCD's proposed rebuttable presumptions of no beneficial use, correct?
Madam
Yes.
Hearing Officer, can we pull up those pages? We're glad to do it unless Ms. Fox is able to.
Right. I'm not going to pull up pages 5 through 8, but I have the quote that I'm going to ask her about on the slide right now.
Okay.
I can't pull up pages 5 through 8. You state on page 5 of your testimony, of your direct testimony, quote, such a presumption not only bypasses individual well evaluations, but also risks premature abandonment of wells that may retain economic or operational value, correct?
That's correct.
And you understand that the presumptions are rebuttable, correct?
Yes, that's correct.
And I've pulled up the proposal as modified after negotiations with OCC. And you understand that an operator may rebut the presumption with information that is specific and unique to the individual well, correct?
That's correct.
I'm sorry, where are you reading from? What's on the screen or from her testimony?
No, I'm just generalizing what the provision provides for in Part D. So submission of well-specific information to OCD would result in an individualized well evaluation, correct?
It would. What is the purpose of what's on the screen, though?
Just to remind you what's in the presumption of no
okay.
beneficial use, in
Okay.
case you didn't have it in your mind.
Okay.
You state on page 6 of your direct testimony that, quote, many viable wells would fall below the thresholds in the provision on rebuttable presumptions of no beneficial use, correct?
That's correct.
Objection, that's not exactly what her testimony says, which is why we would like for it to be on the screen if she's going to reference it.
The testimony's on the screen at the top.
What page is this?
Page 6.
Is this rebuttal or direct?
Direct. You state many viable wells, including those used in enhanced oil recovery, EOR, cyclic operations, pilot testing, or temporarily shut in for maintenance would fall below this threshold. Speaking to the threshold for presumptions of beneficial use.
Give me 1 second. I'm looking for that.
Lines 115 to 16.
Okay, yes. What my testimony says is many viable wells, including those used in enhanced recovery oil, EORs, cyclic operations, pilot testing, or temporarily shut in for maintenance would fall below the threshold.
Correct. Now, neither you nor any NMOGA witness has attempted to quantify the number of wells that would be subject to the rebuttable presumptions of no beneficial use, correct?
That's correct.
I'm showing you applicants exhibit 40, which shows, among other things, the number of production wells in New Mexico that would fall into that presumption of no beneficial use. Are you familiar with this exhibit?
Yes, I've seen it.
And this exhibit shows there's approximately 1,700 wells that would fall into the presumption, representing 2.9% of all wells and 0.003% of all production. And you didn't provide any basis to dispute this information in your testimony, did you?
Not in mine, no, ma'am.
Regarding financial assurance, on page 13 of your direct testimony, and I've got the applicable quotes up here for you. Discussing applicants' proposed financial assurance requirements for marginal and inactive wells, you state, quote, Mr. Arthur explains that adopting these proposed changes would exponentially increase bonding requirements, especially for smaller operators who rely on marginal or stripper wells, which make up 54% of oil wells and 81% of gas wells in New Mexico, correct?
That's correct.
And when you say that marginal or stripper wells make up 54% of oil wells and 81% of gas wells in the state, you are referring to marginal wells as defined in applicants' proposals, correct?
I am referring to marginal as Mr. Arthur uses it in his testimony.
And the beginning of the part of your testimony that we have up on the slide here, you identify, you say Welk's proposed active and marginal well financial assurance requirements impose blah, blah, blah. So you are referring in that paragraph, as did Mr. Arthur, to the marginal well definition in applicant's proposal, correct?
Yeah, I'm referring to his, which if he's referring to Welk's, then that would be correct, but I'm referring to Mr. Arthur's.
Okay, so when you say Welk's proposed active and marginal well financial assurance, you're not necessarily referring to our proposals with regard to marginal well financial assurance?
So yes, but my statement, the bottom statement that you asked me about first, is referred back to Mr. Arthur.
Right, and okay, I'm not going to belabor this. For his part, Mr. Arthur, upon whose testimony relies, states on page 28 of his testimony that, quote, these per well financial assurance requirements for marginal wells will exponentially increase the bonding amounts required under the rule because stripper wells, which he says are a subset of marginal wells, represent 54% of oil wells and 81% of gas wells in New Mexico, correct?
I don't have his testimony up, but if that's what you pulled, I will take your word for it.
Okay. Well, you initially said that you were relying on his testimony. And so since you're relying on his testimony, I am asking you about what that testimony is.
I understand, but I'm just saying that what's on the screen, I don't have myself. I don't have his testimony pulled up.
But but you don't have any reason to think that this is the testimony that I pulled up for you is not Mr. Arthur's testimony, correct?
No, I told you that. Yeah.
Okay. So in New Mexico, what is the maximum production level for stripper wells and barrels of oil equivalent per day over 1 year?
Right now, well, as proposed?
No, I'm talking about stripper wells. What's the definition of stripper well in New Mexico?
I don't have that off the top of my head right now.
You don't know that it's 10 BOE per day over a year?
If that's what you're telling me, I have no reason to believe it's not.
And what is the maximum production level for applicant's definition of marginal well?
1,000 barrels.
So that's about 2.7 BOE per day over 1 year, correct?
I would take your word for it.
So under applicant and OCD's proposed definition of marginal well, the well would also have to produce less than 180 days per year, correct?
Under the current proposed, yes, ma'am.
And so when Mr. Arthur says that marginal wells, referring to marginal wells in applicants' proposals, are a subset of stripper wells, that's just wrong, isn't it?
Can you give me a little bit more color? What, or ask it again, I'm sorry.
That's okay. Mr. Arthur is saying here in his testimony, the testimony that you relied upon, that stripper wells are a subset of marginal wells as proposed by applicants and OCD, and that's just wrong, isn't it?
Objection. Ms. Fox had the opportunity to cross Mr. Arthur, and he's an expert. She's representing the industry. Like, I don't know how she can know whether his testimony is wrong if she relied, just because she relied on it.
Right, she incorporated it into her own testimony, right? So why couldn't she speak to it?
Well, I'm not saying she can't speak to it. I'm just saying, how is she going to verify her own experts, Nemoga's own what experts numbers? I think the question's confusing.
All right, if you want to rephrase, Ms. Fox.
Ms. Felix, stripper wells are not a subset of marginal wells as proposed in applicant and OCD's proposals, correct?
So if I'm understanding, you asked stripper wells are not a subset of marginal wells in applicant's application. That is correct.
And so that both you and Mr. Arthur are wrong when you state that applicant's marginal well category affects 54% of oil wells and 81% of gas wells in New Mexico, correct?
I would not say that. I have no reason to believe that what Mr. Arthur put in his testimony that I accepted as well would be true in his opinion and what he's bringing forth. So I really can't truthfully say that.
Okay, you do say in your sworn testimony that marginal wells or stripper wells make up 54% of oil wells and 81% of gas wells in New Mexico. And all I'm asking you to acknowledge is that's not correct.
Madam Hearing Officer, I'm going to object because what she's referring to, if you go to Mr. Arthur's testimony, cites to an EIA study. So there's context that is not available in the document that Ms. Fox is showing Ms. Felix that actually sheds light on what Mr. Arthur is referring to. So this whole line of
Redirect on this, Madam Hearing Officer.
misleading.
Let me offer a different instruction for Ms. Felix. Ms. Felix, to the extent the answer to Ms. Fox's question would require some, more research on your part into what Mr. Arthur was basing his testimony on. You really can just say, I can't say, I don't know.
Okay. I can't say I don't know.
So thank you, Madam Hearing Officer. So Ms. Felix, you can't say if your testimony is accurate or not.
I can't say what additional information was used to cite that. I would need to do some further research.
And then going back to applicant's exhibit 40, which estimates the number of marginal wells as defined in by applicants and OCD, finding that there's approximately 2,200 marginal wells, exclusive of wells with presumed no beneficial use, representing 3.7% of all wells and 0.045% of total production, correct?
That's what's being shown on this chart.
With a chart you said you were familiar with.
Yes, ma'am.
And you don't have any basis to dispute this data, correct?
No, ma'am.
So while you and Mr. Arthur are saying that applicant's and OCD's marginal well category affects 54% of oil wells and 81% of gas wells in New Mexico. Using the correct definition shows that in fact applicants' marginal well category affects 3.7% of all wells in the state, correct?
Again, objection. It miscites Mr. Arthur's data for this proposal. And unless she's going to pull that up and actually show the full testimony that he provided, this line of questioning, I'm sorry, I just have to object to it.
Ms. Fox, I guess I thought Ms. Fox read what the testimony was.
Well, the testimony is citing to the EIA information, and as I understand it,
Madam Hearing Officer, Mr. Suazo's objections that are not being sustained is eating into my time.
Right.
And he can redirect on any of this, and that's more appropriate.
Yeah. All right. So again, Mr. Suazo, you'll be able to redirect, and Ms. Felix, to the extent you need more information to answer the question, just say so.
Okay.
And I also like to note that I've given a lot of context for the Arthur testimony here and what I'm showing.
I agree with you.
Ms. Felix, on pages 6 to 8 of your rebuttal testimony, you state, moreover, applicants and OCD conflate plugging costs with full environmental remediation costs. As Mr. Emmerich and Mr. Arthur explain, industry plugging costs are significantly lower than the inflated figures cited to OCD's procurement processes. Using these inflated averages to justify $150,000 per well bonding results in rules that are both unworkable and beyond the scope of OCD's authority. And as Mr. Sporich has explained, the statutory authority for the division to demand financial assurance only allows consideration of a well's plugging and abandonment costs, not reclamation, correct?
That's correct.
And so what you're essentially contending here is that the $150,000 proposed by applicants represents a bond for both plugging and remediation and reclamation costs, correct?
That's correct.
So do you understand from the testimony that the 150 from both applicants and OCD, that the $150,000 one well plugging financial assurance is based on the average fiscal year 2024 cost to OCD to plug and plug only, which according to LFC is $163,000?
That's what's showing in the report right here.
What's your understanding?
Yes, the only thing that I would say as well on from the LFC report, the pre-project costs were highest for remediation and reclamation. So that can lead one to interpret that reclamation was also included.
Except
in the report.
Except that in the report, I mean, you'll note that in table 5 of the LFC report, that shows the FY24 average cost to quote unquote plug by well type, correct?
Yes, ma'am.
And then on that same page in the LFC report, which is page 4, LFC goes on to say that while OCD spent more overall in well plugging between FY19 and 24, per project costs were the highest for remediation and reclamation of infrastructure associated with oil and gas production, not well plugging itself, correct? That's what you just referred to.
Yes,
correct?
that's what it says.
Okay, and so then you see in table 6 of the OCD of the LFC report, LFC has reclamation and remediation costs, which are separate from the plugging costs, correct?
That's correct.
And so the LFC report upon which the $150,000 average is taken from actually distinguishes between on the one hand, cost to plug, and on the other hand, cost to reclaim and remediate, correct?
Correct, based off what we just seen on the screen.
And did you hear the testimony of OCD witnesses Lauren Dede, who oversees plugging of orphan wells, and Rosa Romero, who oversees remediation and reclamation?
I heard portions, yes, ma'am.
And do you understand then that within OCD, the plugging work and the remediation and reclamation work are separate?
Yes.
And the costs for each type of work are separate?
Yes.
So your contention and that of Mr. Emmerich and Mr. Arthur that applicants in OCD conflate plugging costs with full environmental remediation costs is wrong, correct?
Based off of what I learned through this hearing, but at the time of submittal of my direct testimony and rebuttal, no.
So you're correcting that testimony right now?
What, ma'am?
You're correcting that testimony right now?
Well, we've learned a lot over the hearing, and I learned that from listening to that testimony.
I want to go to one of NMOGA's proposals. If I could just have a minute here. If I can find it. Shoot, it's not coming up. It's, Hey, Morgan, can I have 1 minute, please? This is not coming up. So, looking for it. Okay, that's what I'm looking for. Is it a word? Sorry about that. Thank you. Ms. Felix, we're looking at NMOGA Exhibit A, which is NMOGA's proposed red line. Are you familiar with that, with NMOGA's Exhibit A?
Yes, ma'am.
And in your direct testimony, you referred to applicants' proposals and NMOGA's concerns with their proposals as Part 5 of the Commission's regulations in 1915, correct?
Can you point me to the portion of my direct that you're talking to?
It's on pages 46 to 48.
And what are we talking about?
So we're talking about NMOGA's Exhibit A and its proposals to 1915-59 that I'm showing you on the screen.
Okay.
Okay. And my question is this, because I was a little bit confused by your red line. And that is, if you look at 1915-59A, NMOGA proposes to strike paragraph A4, correct?
That is what's on the screen. Yes, ma'am.
And paragraph 4 in the existing regulations requires compliance with Part 25. Part 25 is the part that deals with plugging and abandonment, requires compliance with Part 25, and then gives exceptions, allows operators not to be in compliance with those provisions for between 2 and 10 wells. Is that correct?
I believe that's correct. Can we pull up the existing regulations so we can all see?
I'm just going to ask you about this right now. Okay.
Okay.
So if you need it, let
Okay.
me just ask and see so we can hopefully avoid that. Okay.
Okay.
Okay. So my question is this, what NMOGA has done here is strike out paragraph 4 completely. We don't see the strikeout language, which would strike out, not only that compliance with Part 25 is required for a compliance determination, except operators can have, it's a little bit, a little bit confusing, except that operators can have a number of wells out of compliance for purposes of the compliance determination. So my question is this: did NMOGA intend to strike out that entire section so that for purposes of the compliance determination in 1915-59, compliance with Part 25 is no longer required?
I am not sure if that is intentional or if there is an inadvertent error in the exhibit that's showing.
I can proffer that this is an error in that red line.
That's what I was wondering.
But her testimony is correct on this point.
Then was the intent, Mr. Suazo, to leave the provision as is in the existing rules?
Let me confirm. I'm having one of our associates pull up our filings, and I can confirm that in just a little bit. I think that the intent, as I recall, was to leave the small operator exceptions in there.
Okay, to leave Part 25 in for purposes of compliance determination, to leave the exceptions in, so to maintain status quo, essentially.
Yes.
Because here it's completely taken out.
Right.
Okay. That was my question. Thank you. If you could clarify that, that would be helpful.
Sure.
Okay. So Ms. Felix, I really wanted to avoid this discussion.
But you're giving me that look.
But you opened the door to such a great extent during your direct presentation that I am going to plow forward. I'm going to forge ahead, even though I don't really want to. Okay. Let me. Okay. I am going to put up applicant's exhibit 89, which is correspondence between Welk Counsel and Missy Courier, who's the NMOGA CEO, that occurred between June 15th and June 24th, 2024. And you referred to some of this correspondence in your written testimony and during your presentation today, correct?
Yes, ma'am.
Okay. So what I've done here is I've numbered at the bottom of these pages. I've given them page numbers separate and apart from the page numbers in the emails. Do you see that?
Yes, I do.
To easily refer to them. Okay. So looking at page 4, there's a June 15th email from Welk attorney Allie Beasley. And Ms. Beasley informed Ms. Courier of our petition filing and offers to meet, and also states, quote, "We hope to work constructively with NMOGA constructively throughout the process," correct?
You said page 4?
Yeah, page 4.
My 4 is not that.
Okay. I could have gotten that. Page 4 to 5, yes. So if you look on page 5, she says, "Please let me know if you..."
Mine's not like that.
Page 5?
I don't have a 5. Okay. I don't need that? Okay.
Huh. Sorry about that.
That's okay. Now I don't look like I'm confused because I was.
Well, I think we confused you. Okay, so on the bottom of page, on page 5, Ms. Beasley says to Ms. Courier, "Please let me know if you would like to discuss the proposed amendments, and we hope to work with NMOGA constructively throughout the rulemaking process," correct?
Yes, that's correct.
Okay. And so Ms. Courier responds on page 4 on June 17th and says, "Thank you again for reaching out to us, exclamation point." And she copies IPAM and the Permian Basin Petroleum Association and says, "We appreciate your willingness to meet, exclamation point, and ask for dates to meet," correct?
That is correct.
Okay. And Wilk had sent the same email notifying IPAM about the filing and offering to meet, correct?
I don't know if Welk sent that to IPAN.
And so the meeting is set up for June 21st, correct?
Which was the Friday. Yes, ma'am.
Correct. Later in the day of that we arranged the meeting, Ms. Courier said that she would not be able to attend, but that representatives from NMOGA, IPAM, and the Permian Basin Association would be there, including you, correct?
That is correct.
And then looking on page 1 on June 24th, after the meeting, Ms. Courier writes to me thanking us for taking the time to meet, correct?
That is correct.
And I respond that we appreciated the meeting, that I would send a courtesy copy of the filing and stated, quote, "As we expressed to the group, we hope to discuss our proposed changes with you and OCD between now and a hearing in the hope of finding as much common ground as possible," correct?
That is correct.
And you attended that June 21st meeting, correct?
That is correct.
And would you call that a cordial and even friendly meeting?
Yes, it was. It was a very dialogue. You went through verbally what you guys were planning. We asked if you had it in writing. You advised you weren't at that point. We asked if we could see it before you petitioned. There was no promises made. And then you petitioned on Monday as you had planned to do.
So turning to applicants exhibit 6.
Can I have that back?
I took it from you.
I'm old school. I like paper. I mean, this is great, but you gave it to me, so.
We all
Okay.
like paper. Okay. So applicants exhibit 6, which is in evidence, is email correspondence among WELC, OCD, NMOGA, IPAM, and Oxy Council between August 28th, 2024 and March 20th, 2025. So over the course of 7 months. And the email correspondence begins August 28th, in which WELC is trying to schedule a meeting with all parties to discuss and negotiate WELC's proposals. And you'll notice that these pages are bait stamped, Ms. Felix, and that begins on bait stamp number 0224.
Yes.
Okay, so at that point in time, WELC is trying to schedule a meeting with all parties to discuss and negotiate WELC's proposals, correct?
That is correct. I would just add, though, I don't have the exact date off the top of my head, but OCD advised all parties August 24th-ish that they were going to be coming back with a substantive red line. And so at the time of the original request from you, Ms. Fox, the end of August, I can't recall the dates off the top of my head, for starting to engage in those conversations, we did not have OCD's red lines. In October, when these emails and these meetings were set up, NMOGA, because we have multiple member voices, could not add anything substantive because we didn't have the most current red line that we were all expecting from OCD. So I just want to make sure that you understand that, yes, we received these. Yes, Miguel went to one of the meetings, but he was not able to give any input because the input for the perceived coming red line had not been received by our organization yet.
I understand that you weren't at the meeting that occurred, but isn't it true that OCD announced its intent to propose red lines at that meeting, which was October 16th and not on August 24th?
I also recall, like I said, I think it's the 24th, but there was notice to the parties that a red line would be coming.
Okay, in any event, let's tromp through this
That's fine.
correspondence.
That's
Okay, and I promise I will try to do as quickly as possible, but I do really want to set the record straight with regard to the efforts that applicants made to engage NMOGA and IPAM. Looking at base stamp numbers 222 and 223. After a lot of work to schedule meetings, by September 4th, Welk was able to set up 4 2-hour meetings in October, beginning October 16th, to discuss financial assurance and inactive wells, correct?
That's correct.
And then looking at 222, I asked on September 5th if parties have alternate proposals, would they please send them, correct?
Yes, ma'am. That's what's on here.
And then looking at 230 to 231, on October 8th, I sent a reminder for the meetings for which a calendar invite had been sent, and proposed rather detailed agendas for the meetings, correct?
That is correct. Yes.
You just pull those up. Okay, and then I reiterate at that time that if any party has proposals or red lines, we'd like to see those, correct?
Yes, that's correct.
So then the 4 meetings were to take place in October 2024, essentially 1 year ago, correct?
Yes. Flashback. Time flies when you're having fun, getting ready for rulemaking.
Yeah. So looking at 229, on October 11th, Mr. Suazo emails to say that both NMOGA and IPAM now have conflicts and can only meet the first day, October 16th. And can we talk about both FA and inactive wells, correct?
Yes, that's what's on here.
And then I write back and say, well, we can collapse the 4 meetings, but please know that applicants remain, quote, applicants remain open to good faith negotiations after meeting next week, correct?
That's what it says. Yes, ma'am.
And did you hear Mr. Alexander's testimony that the one meeting that was held was non-substantive in terms of negotiations?
I did, but I also heard him refer that he's been preparing for this since 2023 with you all. So that's why I just stand firm on the good faith efforts.
I am not going to go into the extensive negotiations on oil and gas reform that Welk participated in with industry over the course of 5 months. So just, were you part of those negotiations at all?
Not, but I've heard the stories. Okay. And you brought that up. So since you brought that up, I will tell you that when this proposal made prime time and we announced to members the overwhelming amount of deja vu, we just went through all these exhaustive discussions through the legislative process. Now we're going to have a rulemaking. Members felt like they were being attacked. Like, I will just say that. So that is where we feel that, yes, you did offer these meetings, Ms. Fox. There's no denying that. However, we were waiting on what we had been advised we were going to receive in the form of a red line. And the division is the responsible authority who would be administering. We felt it was prudent to have that for these discussions to be fruitful. So I'm not arguing that these emails exchanged didn't happen. I'm not arguing that you didn't extend. I am just simply bringing clarity to on industry's side of how and when in the time frame it put us in a corner.
So you were really waiting for OCD's proposals to negotiate?
Not to negotiate, but to have the discussions, because we were advised that OCD was going to provide a maybe I'm not using the right term right now, so I don't want to lie. I'm under oath, right? But I believe the word, I believe the word was substantive red line. And so again, working with a trade organization, you know, if I were here representing company A and simply company A, 100%, I could have been at the table with Oxy. I could have been at the table with the other parties, but representing over 240 member companies, I have to have that input and the feedback from the overall industry. That's what a trade association is. So I'm not bashing, I'm just, how it was laid out simply put us in a bad position.
But you were waiting for OCD's proposals to negotiate, correct?
Not negotiate, but to have the discussions.
Okay, so during the October 16th meeting, OCD did either initially or reiterate that they would have a red line proposals for the parties by the end of the year, correct?
I believe it was before Thanksgiving.
End of November, correct?
I believe the correspondence I seen was by Thanksgiving.
And so moving on to 234.
How much time is left, Madam?
Oh, I was about to break in, actually, Ms. Fox, you have about 5 minutes, even adding a few minutes.
Okay. In December, moving on to 234, on December 10th, I write to the parties and offer actually to postpone the hearing schedule because OCD has been delayed in getting alternate proposals to the parties. And a postponement will give the parties an opportunity to meet and discuss OCD's proposals, correct? Which are now expected in the new year.
That's correct. I believe, I thought it was January when OCD filed the request for the extension based off of their red line. I could be wrong, but ish.
Yeah, so, but what's happening here is that in December, applicants are actually proposing to postpone the hearing in order to receive OCD's red line, correct?
That is correct. And then I believe the OCD actually petitioned to postpone the hearing.
That was actually, wasn't that actually a negotiated hearing schedule that was initiated by applicants?
I don't know. I know all parties agreed to it, but I believe what my meant to say, if it didn't come out clear, is that OCD filed for the petition for rescheduling based off of their intention to submit all parties a red line.
Wasn't it actually applicants per this email and that initiated the delay, the rescheduling?
I will say in the email here, yes, but I was simply saying that it was OCD that filed for the delay.
Okay, well, the record will reflect what actually happened.
Yes, ma'am.
And so then OCD comes out with its proposals on February 12th, correct?
That's the right date. You and I memorized it.
Yep. And looking at 237, isn't it true that Mr. Tremaine proposes to the parties to hold stakeholder meetings in April after the legislative session ends, correct?
That is correct.
And then a few days later, I respond agreeing on behalf of applicants to meet, correct?
That is what's here. Yes, ma'am.
And then there's no email, in this correspondence, there's no email correspondence from NMOGA, correct?
Not in what I have in front of me. That's correct.
And as far as you know, did NMOGA or IPAM agree to negotiations with after OCD proposed to sit down and talk about their red line?
No, ma'am. NMOGA's membership and our board has not approved for negotiations. discussions. However, I don't know what date, and again, ish, but then we received another red line from the applicants.
Would you say that applicants made good faith efforts to negotiate with industry after filing the petition?
I would say after filing the petition, yes, ma'am.
And that was about 1.5 years ago.
Yes, ma'am.
That's all I have.
Thank you, Ms. Fox. Let's see. Mr. Tremaine or Mr. Hall, you would only be able to do 10 or 15 minutes.
I may be able to get through, hearing officer, or we can break for lunch. I serve at the commission's pleasure.
It would have to be a long break, right? Sharon Palmer? Oh, not today. Okay, so we can. Oh, it is today. Okay, so yeah, it would be a long break.
So better move forward.
Yeah.
Great. Okay. Good morning, Ms. Felix.
Good morning, Mr. Tremaine.
Still morning barely. Okay. It's good. We've crossed paths before, but as we said, we haven't, don't believe we met in person. So it's great to meet you. Ms. Felix, did you hear my opening statement?
Yes, I believe I did.
Okay. I sincerely meant what I said in my opening statement. My observation is that typically the MOGA acts as a willing participant in discussions with OCD on a wide range of issues. And despite the fact that we're litigating some points in this hearing, our hope and expectation is that dynamic continues. So just wanted to preface with that.
I appreciate that. And I would just build off that really quickly, if you'll let me. While I heard through the testimony of OCD, if we expected industry to come to us, we hear you loud and clear, but we were being very respectful to the process and to the applicants as well.
Great. Ms. Felix, Ms. Fox went over in some detail the structure of your testimony and reliance on other witnesses. So I'm not going to touch on that or duplicate. But I want to ask you, did you observe yesterday when Mr. Sporich on cross conceded that applicant and OCD's interpretation of 70-2-14A, the rainbow slide, that their interpretation was credible?
I believe I did hear that when he had Rankin's rainbow up.
Okay. Does that change your view of the proposal in any way?
Honestly, I would have to put some thought to it to tell you the truth. And I guess I should have, but I didn't. I'm sorry.
Okay, that's all right. Very general question. Do you believe that if the commission were to promulgate the rules as written or close to as written, do you believe that the OCD should incorporate review of any kind of operator financial information when it is assessing transfers?
Can you repeat it one more time?
Yeah. Do you believe that OCD should incorporate the review of any form of operator financial information when it is reviewing whether to approve or deny a transfer of operatorship?
So I would just start that out with that I rely on legal counsel's determination of authority in those regards, and the division having that authority per statute. If the proposed amendments for that review, I believe that we would need to have a very transparent and tiered approach to that so that it's not burdensome on the division as well as industry.
Are you aware, strike that. Would you, I don't want to belabor this point if you're referring to relying on the advice of counsel. So would you provide the same answer if I asked you that question regarding OCD review of operator financial information regarding an operator's rebuttal of the presumption of no beneficial use?
I would say my answer is the same.
Okay. Did you hear the testimony, particularly on cross-examination of Mr. McGowan, where he acknowledged that operating in an undercapitalized position or failing to reserve capital for decommissioning costs represents a greater risk of orphaning wells in that portfolio?
I believe I did hear that under that context.
Okay. But based on your prior answers, I have to assume that you wouldn't change your position after hearing that testimony because you're relying on a legal analysis?
That's correct.
Okay, I'll move on. So in your testimony, is it fair to say that you've raised, strike that. I'm going to refer you now specifically to the presumption of no beneficial use as proposed. And is it fair to say that your testimony raises some concerns about how OCD will implement that process?
Implement, interpret.
Implement and interpret. Okay, great. Will you agree or concede that a determination of no beneficial use is already incorporated in the existing provision of 19.15.25.8?
Can we pull it up? I don't want to lie, Jesse.
No, certainly not. Let me pull it up here. Pardon. So Ms. Felix, no tricks here. The red lines can get kind of hard to read. So what I'm proposing to do is just show you from New Mexico Compilation Commission the existing rule. I don't believe this should be controversial, but I just wanted to go back to a version that didn't have a red line. So I want to highlight here for 19.15.25.8, if you go down to B2, this is the existing rule, which was promulgated in 2008. Can you read B2 for me, please?
A determination that a well is no longer usable for beneficial purposes, or.
All right. So, so would you agree that based on reading this, that determination of no beneficial purpose, use of beneficial purpose is already incorporated in the rules?
Yes, sir. As shown on the screen, yes.
Okay. And I had some cross for one of the other NMOGA witnesses, but I want to ask you, can we agree that beneficial purposes is not defined in the current rule?
Yes.
Okay, so if OCD were to utilize this section of rule that already exists, wouldn't you have concerns that elements or criteria for how OCD determined no beneficial use would be problematic for your members?
Say it again.
Yeah, this is a tricky question. So if there's no definition of beneficial use, right? We're agreeing on that. And if OCD issued a determination of no beneficial use, and your membership, someone in your membership with NMOGA received that determination of no beneficial use, wouldn't it be problematic that in your membership's eyes that there's no definition or process associated with that determination?
I think the potential is there and likely open for interpretation.
So can you agree that the proposal of both the definitions and the process and the rebuttable presumption elements are an attempt by OCD to provide clarity on the existing rule and provide a specific process by which OCD and operators can rely?
I think that based off what I've heard through the last 2 weeks from through OCD's testimony, that was the intent.
But that wasn't your interpretation on simply reviewing the petition?
No, sir.
Okay. Are you generally familiar with the OCD's notice of violation process?
Generally, yes, sir.
Okay, it's not, I'm not going to trick you.
Don't trick me.
Get specific things. Can we agree that there is, in the rule and in application, there's an informal resolution period for notices of violation?
Yes,
Okay, and those apply to every NOV?
I believe so.
Okay, and that those are 30-day informal resolution periods?
I believe that's correct.
Okay. Do you understand, is it consistent with your understanding that OCD has issued approximately 112 notices of violation?
Say it again, I'm sorry.
Is it consistent with your understanding that OCD has issued approximately 112 notices of violation since the rule was updated?
I will take your word for it.
Okay. Would you take my word for it that 80 of those are resolved?
Yes, I would.
Would you also take my word for it that 53 of those resolutions were settlement agreements?
Yeah.
Would you also agree that of the NOVs, and this is in Mr. Powell's testimony, but approximately 39 of those relate to inactive wells?
I'll believe you.
And of the 32 resolved inactive well NOVs, 20 of those went to hearing?
I'll believe you. So did I hear this right? 39 inactive wells, 30 resolved?
39 inactive well NOVs, 32 resolved either
Okay.
through hearing or settlement. And 20 of those resolutions came from hearings. So 12 were settlements.
Okay.
Okay. Would you agree with me that outside of inactive well NOVs, OCD really has not needed to take any other subject matter NOVs to contested hearing?
Not that I've seen, no.
And we've referred in earlier testimony to OCD Exhibit 24, which is an ACOI list. Would you, have you reviewed that at all?
Yes.
Okay. Would you agree that there are over 100 agreed compliance orders for inactive wells since 2017?
I would agree.
Did you hear Mr. Powell's testimony that the enforcement mechanisms that OCD has available, despite concerted effort to come to reach settlements and negotiate resolution with operators, has proven ineffective in the last 5 years?
I did hear him say that.
Would you agree that there's a problem there that needs to be resolved?
So on the inactive list, here's a couple of my thoughts. It would be interesting to know, because the tools in OCD's toolbox to, put the stick to industry, if you will, are issuance of APDs, issuance of authority to transfer gas, all that good stuff. So of those operators on that ACOI list that make up that non-compliance, one would have to assume they would be operators that are not active and prudently operating today. I just think there needs to be a little bit of clarity of what's behind there. Is this operators that are not active and in current day oil and gas world, or are these operators that the tools in the toolbox aren't being utilized per the inactive list? Does that make sense?
I think your distinction does make sense, but responding to it would.
I know. I'm sorry. I didn't mean to ask you a question, but
I can't testify. But I would submit in response and for the record that if OCD is settling an NOV or issuing a settlement agreement, that the operator is alive and kicking. They're doing something, even if they have compliance problems.
Okay.
Yeah.
Thank you, Mr. Tremaine. Could you finish your questions after lunch?
I certainly may.
Thank you. Let's break till 1.